night on the CINA 102.3 app at cinafm.com, on TuneIn, on Smart Speaker, and at 102.3 FM. Cina Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of Cina Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. جومانا كيروز ومكتبها الذي يستقبل قضاياكم المتعلقة بالبيرسونال انجريز، قضايا كار اكسيدنت، قضايا الهجرة والتجنس، قضايا الإفلاس والكريمنال لو، فاميلي لو، وقضايا ضمان اجتماعي وإصابات العمل. الاستشارة مجانية ورقم الهاتف هو 248-557-3645. حلقات برنامج يور رايتس تعاد مرة أخرى وموجودة على الموقع الإلكتروني yourrights.com، وأيضا على اليوتيوب. كل ما عليكم هو البحث عن قناة جومانا كيروز. تحياتنا لكم، أهلا وسهلا بك جومانا في راديو سينا.
صباح الخير.
صباح النور.
يعطيك ألف عافية.
الله يعافيك، يا أهلا وسهلا.
صباح الخير لكل المستمعين. صباح الخير للضيف تبعي اليوم المحامي هوارد رادنر، اللي بالمعدل بستضيفه تقريبا مرة بالشهر، لأنه هو بيقوم بقضايا نحن بالمكتب ردنا ما نقوم فيها، اللي هي قضايا premises liability, slip and fall, trip and fall, إلى آخره. Good afternoon, Attorney Howard Radner. Happy to have you here today.
Thank you. I'm delighted to be here again, Joumana.
Thank you. How are you doing today?
Great, thank you.
That's good. We want to tell the listeners that we have about 50 minutes, and we are more than happy to take any of the listeners' calls, questions, or comments about the topic that we are talking about today, that being, again, in English, we call it premises liability, meaning slip and fall, trip and fall. It may be arising out of a landlord-tenant issue. It may be an injury at a gym. It may be an injury at the grocery store. It may be an injury on a city sidewalk. It may be an injury at a stadium. It may be, you think of other injuries that I have not mentioned. City sidewalk, visiting somebody's home, outside somebody's home, sports arenas, working out in a gym, at a school, and so forth. Correct?
Sure.
Okay.
Could be crossing the street also.
Could be crossing the street. Okay. An injury that doesn't involve a car, because it could be 2. It could be both.
Could be a defect in the roadway.
Correct.
So.
Correct. So anyone who does have any questions, comments about any of these areas should feel free to call at 313-769-6666, and from Windsor 519-256-1023. Howard, yesterday I sent you a number of articles, and I know these articles talk about cases. Most of them, I think, are Court of Appeals decisions outside the state of Michigan. But I wanted to discuss them with you, tell you a little bit what happened behind every article. One is in New Jersey, one is in New York City, one is in California, one is in Houston, Texas. One, that 4-year-old, that's not a case. That's an article written by an expert about what happened at a baseball stadium last week, and a 4-year-old little girl, got hit. Yes, these cases or these scenarios did not take place in Michigan. We know that the laws in all 50 states and U.S. territories, but in all 50 states, vary. They're not always the same. Quite often they're more similar than different. But we're going to talk about every scenario, and we are going to talk about how do you believe, based on your 40-some years of experience?
44.
44.
Almost 45.
For almost 45 years of experience handling, premises liability, slips and fall, trip and fall. What's your opinion or your take is on this? The first article that came out yesterday was about a lady who lives in New Jersey. She is a resident of New Jersey, and she lived in an apartment building. And in fact, she occupied the ground floor of an apartment building. Very unfortunately, she was sexually assaulted by someone who came in through her broken window, a window that she had notified her landlord about, but her landlord did nothing about that. So an intruder, someone from the outside, jumped through that broken window and very sadly sexually assaulted her. And the reason I wanted to discuss that article with you is because it does give us a chance to talk about the duty of landlords, whether it is in a home or whether it is in an apartment complex. And I know you've done a lot of those to great success. You've taken a lot of these cases to great success. The duty of landlords. And in this particular case, the duty was about the landlord as far as safety is concerned. It appears that this young lady did notify she lives on the ground floor, and her unit is on the ground floor, and her window was broken and it did not lock properly. She notified her landlord, but her landlord did not do anything about it. He did not respond to her concerns, leading somebody to come in and sexually assaulted her. So she did file a lawsuit against her landlord, and her landlord has an insurance company. And the insurance company, in essence, said that this is not covered. This is not one of the duties of the landlord. Because, tell me if that exists here in Michigan, but in that particular case, in the contract between the landlord and the resident who lived in his apartment, there was a language in that policy that his insurance company offered him that said that coverage is barred, meaning there is no coverage for any claim, demand, or suit based on assault and battery. Based on assault and battery. But her lawyer was very clever. He sued, not saying that her landlord committed an intentional, tort. He said that her landlord was negligent. Can you tell me here in Michigan, and by the way, she won, the insurance company for the landlord did not want to cover this because they wanted to invoke that part of the policy that says that a landlord is not responsible when someone is injured as a result of an assault or a battery, including sexual assault. Can you tell me what the law here, or the cases that you've seen here in Michigan, or the law, if any, by case law or otherwise, says about when people live at landlords and they become the victims of some kind of assault, whether sexual or whether just a robbery and so forth?
Sure. Well, that case in New Jersey, it could be that the landlord would be liable to the tenant.
It is. It did say it is.
It said that the landlord was liable.
It did.
Because even though the insurance company denied coverage, the landlord doesn't necessarily get off the hook. The landlord could still be liable out of his own assets if he was considered negligent in not providing secure premises.
But when you sue a landlord, regardless of his insurance company, or even if he does not have an insurance company, he is not off the hook. But a contract between two people, a landlord and a tenant, we have a lot of listeners who rent homes. It does not have to be a unit in a residential, 30 apartment building or 100 apartment building. The duties between a landlord and a contract are covered in two ways. Correct me if I'm wrong. That is what the statutes require. That is what the law out there requires, that no landlord can avoid or get out of, and there is also the particular contract between the landlord and the tenant, as long as it's not inconsistent with what the statute requires, correct? This language in the policy that the language comes from the insurance company for the landlord. So the policy that the landlord bought from his insurance company states that we are not going to cover you, landlord, if your tenant is the victim of an assault or a battery, such as a sexual assault. What about here in Michigan?
Well, first of all, in Michigan, we have a rule that a proprietor is not responsible for protecting his customers from criminal acts. Now, that was a Supreme Court decision from decades ago, perhaps 30 years ago or more. And I don't believe that there's been a case from our Supreme Court with respect to landlords, but one could argue that logically that case would apply to landlords too, that landlords are not responsible for protecting his tenants from criminal acts.
But in this case, she told him about her broken window, and he did not fix the broken window. She was right to sue and say that he was negligent, because had he fixed my broken window, there will not have been an intruder to steal or sexually assault or whatever. So it's really, landlord, your negligence in failing to fix my window. I think even here in Michigan, we can argue the same thing. Forget the sexual assault, forget the criminal act of the intruder. There may not have been an intruder if the window was fixed, because isn't it the landlord's duty to fix the window if it's broken?
It is, certainly, but that doesn't necessarily make the landlord liable. For instance, what about if the intruder had broken the window or broken the lock on the window?
Correct.
Or broken through the door?
Okay, but in this case, though, it was previously broken and it did not lock properly, and that's how the intruder got in. But if the intruder broke the window and came in, then the landlord is not.
Certainly not liable.
Okay.
But still, I could see an argument on behalf of the landlord that because of that one Supreme Court case that insulates proprietors from liability for criminal acts against his customers, that you could say that logic applies to a landlord-tenant setting as well, and that the landlord would not be responsible for sexual assault on his tenant, even though the criminal went through an unsecured window.
The case that you have referred to, that's 30 years old, is that a Supreme Court case?
Yes.
Is that a U.S.
So it was a
Supreme
Michigan Supreme Court
Michigan
case.
Supreme Court case, okay.
That was a case, I believe, that was filed against Cunningham's, the old drugstore chain.
Okay.
And there are persons sued claiming that Cunningham's owed him a duty because it was a high crime area to protect him from a criminal act, and the Supreme Court said no.
Okay. We are talking for the rest of the hour with our guest, attorney Howard Radner, who specializes in premises liability, slip and fall, trip and fall, landlord, tenant, issues that arise out of slip and fall or trip and fall, what the landlord's responsibilities are, and so forth. I'm going to quickly summarize this before we move on to our next subject. رامي، أول كيس طرحته مع المحامي هاورد رادنر هو بيجي من نيوجيرسي. في سيدة بنيوجيرسي كانت عايشة على الطابق الأرضي، وبالطابق الأرضي تبعها كان في عندها ويندو، يعني شباك كان ما بيسكر وكان مكسور. بلغت اللاندلورد تبعها، وإنما اللاندلورد ما عمل شيء. للأسف فات شخص عبر الشباك واغتصبها، فقامت دعوة ضد اللاندلورد. فاستغنمنا فرصة هيدا الارتكل لنحكي عن شو مسؤوليات اللاندلوردز، يعني اللي بيأجروا بيوت أو بيأجروا شقق للأشخاص، وهل أي إصابة جنائية criminal act هون في ولاية ميشيغان. هذا الكيس اللي عم نحكي عنه هو بنيوجيرسي، وبنيوجيرسي محكمة الاستئناف قالت انه فيها تقوم دعوة ضد اللاندلورد مش لانه هو مسؤول عن الكريمنال اكت. اغلبية بوليسات التأمين اللي اللاندلورد بيشتريها من الانشورنس كومباني بتقول انه لو شو ما كانوا مسؤولياته لللاندلورد اللي بتغطيهم الانشورنس، منه مسؤول عن شيء اسمه كريمنال اكت، منه مسؤول عن assault and battery. وانما هيدا الكيس المحامي تبعها قال انه هي كانت اهمال، ما كانت قصة اغتصاب. يعني لو اللاندلورد اللي كان مبلغ سابقا عمل واجباته وصلح،
ما كان بيصير شيء هذا. الأرجح
انه ما كان صار، more likely than not ما كان صار. يعني اللاندلورد كان مهمل وهي ربحت القضية. هون بميشيغان بيقول لي المحامي هاورد انه من 30 سنة الميشيغان سوبريم كورت، يعني المحكمة الاعلى شيء بولاية ميشيغان، قالت انه نحن ما بنحمل مسؤولية اي لاندلورد لاي كريمنال اكت ذات الشيء. وانما هون كمان لو كانت هيدي السيدة هون ممكن كنا نقدر نفرجي انه هيدا اللاندلورد هو منه مسؤول عن الاغتصاب، بس مسؤول عن الإهمال لأنه كان مبلغ سابقا and had enough time بالمبدأ assuming يعني that he had enough time، يعني مش بلغته قبل بساعة وصار إنه you gave enough time. إذا هو أهمل وما صلحها ساعتها هو صار negligent، هو صار مهمل، والإهمال تبعه سبب الإصابة بدخول هيدا الانترودر واغتصاب هيدي السيدة. So استخدمنا أول ارتكل لحتى نحكي عن واجبات اللاندلوردز أو جزء من واجبات اللاندلوردز في ولاية ميشيغان. The second article I want to talk about in passing very quickly is it's a crime, it's a criminal matter because and it is in Manhattan. It was represented by the Manhattan U.S. attorney, and they found 3 men guilty of trip and fall and slip and fall scams. So just in passing, apparently 3 men got together in New York and solicited and recruited hundreds of people to create fake slip and fall and fake trip and fall, and from there guide them to specific doctors, specific lawyers to file an illegitimate, a fraudulent, a bogus lawsuit, even encouraged these people to undergo surgery, unnecessary surgery, and paid them money for doing those surgeries. So, you know, the trial, interestingly, they got, you know, the U.S. attorney filed a lawsuit, and they got after their indictment, and the trial lasted until 2 days ago. It lasted 3 weeks in New York, and you know, the district attorney said that these people were targeting poor, vulnerable, needy people to play along in their schemes, and they steered them to complicit lawyers, chiropractors, and doctors, and you know, they ask people to testify in exchange for giving them immunity deals and so forth. So these fake victims, you know, they had it down to a science. These 3 people, they knew, you know, what good accident sites and what good, you know, how to fake the injury and how to coach people to do all of that. These were all fake. We used to hear a lot about fake, you know, hit and runs until insurance companies caught on to them. This was about hundreds of people engaged along with 3 mastermind people in fake slip and fall and triple fall in New York City, in Manhattan. Well, it was brought in Manhattan. And as a result of that, they were able to scam insurance companies as well as owners of places to the tune of $31.79 million.
Were they convicted?
Yes, they were convicted. The 3 of them were convicted yesterday. They will be sentenced sometime soon. However, yes, they were convicted. All 3 of them. Any comments on that?
It's outrageous. Have to hope and pray it doesn't happen again.
Do you hear about that here in Michigan at all?
No, not at all.
Okay. Why do you think? Why do you think in New York, you know, they were able to get away with it for this long, since 2000 and I believe 13. Any thoughts on that?
No.
Okay.
I don't know why they got away with it as long as they did, but thank God they got caught.
Yes.
Now they'll be punished.
Before we move on to the next topic, رامي إذا بتسمح لي لخص امبارح بنيويورك بمنهاتن 3 أشخاص انحكم عليهم. They were found guilty بعد ما إجا وقت هون بأمريكا أول شيء you get convicted أو بتطلع براءة، بعدين بيعطوك تاريخ من بعده for sentencing، يعني بتجي لحتى لأنه القاضي بيكون عنده minimum وماكسيموم، عنده sentencing guidelines. So بترجع بوقت لاحق for the sentencing. فكنت عم بسأل المحامي هاورد رادنر إذا بيسمع عن هيدول الكيسز هون بميشيغان، لأنه للأسف مرقنا بفترة وبدون شك من وقت إلى آخر، بس مرقنا بفترة بالزمانات مش من كتير زمان كان في staged hit and run. هيني كتير إني hit and run أهين من غيرها، أو بالأحرى كانت أهين من غيرها. So سألته إذا سمع عن هالشي هون بميشيغان، بيقول لي لا. خلاصة الأمر في 3 أشخاص بنيويورك حوشوا مئات الأشخاص اللي هن يعني فقراء أو بيحبوا المصاري، علموهم كيف يفتعلوا إنه هن يوقعوا أو إنه هن زحطوا، وبمساعدتهم قدروا حصلوا على 31 و800 مليون دولار من الانشورنس كومباني ومن أصحاب الأماكن اللي وقعوا فيهم هدول الأشخاص. يبعتوهم عند محاميين متطابقين معهم، مع دكاترة متطابقين معهم، شجعوهم يعملوا عمليات منهم بيحتاجوها، دفعوا لهم مصاري ليعملوا عمليات، انلقطوا. This was a scam, this was fraud. هيدي fraud. This was a criminal thing. Interesting إنه أخذت الجوري 3 أسابيع لحتى طلع الحكم امبارح. انتقالا لارتكل آخر تسمح لي احكي معه وبعدين منلخصها. هي بتخص sports inside schools. بنحكي شوي وبعدين منلخص، وكمان مرة اللي بيحب يتصل يعلق 313-769-6666 ومن وينزر 519-256-1023. أي قضايا انزلاق، slip and fall, trip and fall، لا سمح الله إصابات ضمن بيت حدا مستأجره أو ضمن أبارتمنت حدا مستأجره. يمكن يكون مستمع هو لاندلورد بيحب يعرف شو معه وشو عليه، بيحب يعرف شو القانون بيطلب منه لحتى يقوم بواجباته كلاندلورد ويتجنب lawsuits. The next case that I also sent you has to do with, generally speaking, sports inside schools. A lot of our listeners have children that do gymnastics, that do small league, that do a number of sports. And this case in particular is from California. And this young lady was a cheerleader. She lost at the trial level. She appealed to the California Court of Appeals. The California Court of Appeals said the same thing. She said, sorry, but you're injured because you are a cheerleader. You know, when you take on sports like cheerleading, you are assuming a very large risk. We don't see how your coach and we don't see how your school has done anything to increase that risk. So yesterday, the California Court of Appeals said, too bad. And the facts of the case are as follows. This young lady was a cheerleader, and in 2014 she sued her school and she sued her coach, saying that she suffered 3 concussions while she was learning and practicing to cheerlead and doing her cheerleading. And she said that those injuries caused her, you know, neurological problems, dizziness, fatigue, vision problems, sensitivity to light and to noise. And the trial court said, I'm sorry, the school has not done anything wrong. It was not negligent. Neither was the coach, because you, Stevens, you cheerleader, you knew what kind of sport this is, and you kind of assumed the risk, because the kind of sport that we're talking about, I mean, if you think about it, being a cheerleader, and this case has more than to do than being a cheerleader. We're talking about, you know, high school athletics and youth athletic leagues and you know, all of these. They did say that, you know, it's the kind of, she was a baser, the kind of stuff that this young cheerleader did. She'd have the other cheerleaders, you know, she would catch them, she would lift them, she would perform stunts in the air, she would catch other cheerleaders that were performing stunts in the air, and so you knew all of that. And the way she was injured is while she was practicing, she was hit in the head by some flying object. That's the first time, and the second time, one of the cheerleaders fell on her, and so forth. And so, you know, there was a lot of back and forth about what a concussion protocol, because she did end up going to the doctor, and the doctor said you have a concussion and told her what she needed to do, and she needed to take a month off from cheerleading, and then she can go back to school and so forth. And, you know, her argument, this young cheerleader, her argument is that her coach should have instructed her to do more. Instead, her coach the first time told her sit on the side and just recover for 5-15 minutes. The second time she did the same thing, and the cheerleader said, you know, there is a whole concussion protocol that you should have, you know, helped me with, and so forth. And because you didn't do that, you increased the risk of harm to me. But the Court of Appeals disagreed. The Court of Appeals said, you know, it's very interesting. They said that coaches in schools and in small leagues and in high schools, and I'm quoting, you know, must be able to push or challenge students so that they can grow and advance, even if in hindsight the activity is beyond the student's physical ability. So and they also said that to impose additional duties on schools because of these kids who play sports would be very costly. It would require more cost and so forth. And no, we think this is over and above. This young lady, as a cheerleader, she knew what she was getting into. It was an inherently risky kind of athletics, and you know, you assume the risk, and we don't see how the school needed to do anything more. Every time you reported something, they put you aside for 5-10 minutes. There was no need to send you to a doctor. You went to a doctor on your own anyhow, and there isn't more that we really need to. And I think that this raises the question to all of our listeners who have kids who are in school sports, who are in school athletics, high school athletics, youth athletic leagues, and all of that. Tell us, here in Michigan, what is the duty of a school vis-a-vis its students who engage in athletics? And we know that athletics, there is always a danger. There's always a danger.
I can tell you that if it's in a public school, the school is immune from suit.
Okay.
So that even if the coach, teacher, principal, aide is negligent, they can't be found liable.
Okay,
if
but
it's
like
a public school.
It's a public school, so there is immunity, but the immunity doesn't apply 100% of the time, unless you can find egregious.
If you found, gross negligence would be an exception. The individual could be held liable for his gross negligence, although not the school board or the city.
So the coach could be, the school coach could be grossly negligent, but the school remains immune. Mm-hmm. So the school coach, if is not collectible.
Well, now as a practical matter, what happens in these cases, if there's a suit filed against an employee of the school will come in pursuant to contract with the employee and defend him.
Okay, so if the coach is employed by the school under the respondeat superior, an employer is always vicariously liable for the acts of its employee?
Not in this case, but the employer may have a contract with the employee to indemnify him for any suit, so that the school may very well come in and defend the coach. And if the coach is found liable, it could be that the school will pay the judgment on behalf of the coach.
Okay.
But the school itself cannot be found liable.
Okay.
Because
what if
of
it is a private
immunity.
school?
That's entirely different. Then there's no governmental immunity for a private school or for the employees of the private school. then each individual in a private school, as well as the school, could be sued for ordinary negligence.
Okay, and so let's talk about the facts of this case. If this cheerleader were to live here in Michigan in a private school, just based on the facts, it would be, it's going to center down on whether or not her coach was negligent in any way. It's going to be very fact specific. What did she tell the coach? What was she manifesting as finest sign of symptom? What did the coach do or did not do that she should have not done or done, correct?
Right.
So, okay. All right. رامي عم نحكي عن كيس من كاليفورنيا كمان بفتكر من 3 أيام. محكمة الاستئناف قالت انه محكمة الواطية يعني الكورت الترايل كورت كان معها حق. خلاصة الامر في بنت صغيرة يعني عمرها تحت 18 سنة، هي تشير ليدر بقلب مدرسة إلها، وبسبب التشير ليدينج تعرضت 3 مرات لإصابات، والحكيم شخصها بشيء اسمه concussion. قررت تقيم دعوة بال2014 ضد الكوتش تبعها بالمدرسة وضد المدرسة تبعها. اللور كورت الترايل كورت قالت ما فيكي، لأنه أول شيء أنت وقت عملت تشير ليدينج، وقت اللي أنت قررت منك لحالك أنه تكوني تشير ليدر. تشير ليدينج يعني you are assuming the risk. This is the kind of sport where there is an assumption of risk. يعني أنت عارفة تشير ليدينج فيها خطر. التشير ليدر بينط بالهواء، التشير ليدر بيستلقى اللي ناطط بالهواء، التشير ليدر بينط على غيره بالهواء، التشير ليدر ممكن يوقع عليه شيء. تشير ليدينج منا شغلة ما فيها ريسك. فأنت وقت اللي قررت تعملي تشير ليدينج you assumed that risk. بيقولوا كمان انه ما فرجيتي انه الكوتش او المدرسه باي طريقه او باخرى كانوا هن مهملين تجاهك. هن منهم دكاتره، مش واجباتهم انه يكونوا دكتور. هي لانه بتقول البنت انه كان لازم يتبعوا شيء اسمه concussion protocol. يعني وقت اللي عرفت الكوتش تبعي من بعد ما رجعت تاني مره انه الحكيمه شخصتني بكونكشن، لازم يتبعوا اشياء معينه ليحموني. قالت للمحكمة تبع الاستئناف سوري طفلك، بس ما مش مجبورة المدرسة ولا مجبورة الكوتش انه تتبع بروتوكول اللي انت عم تطلبيه من المدرسة، مكلف ماديا وغير ضروري. وقالت انه الكورت اوف ابيلز قالت انه بكاليفورنيا انه الكوتشز هن بحق لهم انه تو تشالنج ذا ستودنتس، يعني تو بوش ذم لحتى يكبروا، لحتى يعملوا احسن من طاقاتهم. هيدا الموضوع بيطبق على اي شخص عم يتسمع علينا، اولاده احفاده هن بقلب المدارس وبيعملوا اثليتكس. لو شو ما كان الاثليتكس، هلا مش كل الاشياء خطره مثل التشير ليدينج، يعني الجيمناستكس يمكن خطره اقل حسب شو الجيمناستكس. بس هيدا الموضوع اللي عم نحكي عنه مش بس applies to cheerleading، هيدا الموضوع applies كمان لهاي سكول اثليتكس، ليوث اثليتيك ليجز الى اخره. سالت المحامي هاورد رادنر اذا كان هيدا الكيس بميشيغان كيف بيكون كيف برايه بيكون القرار من المحكمه. هون بيفرق بين المدرسة الببليك والمدرسة البرايفت. المدرسة الببليك هي حكومية، والحكومة كقاعدة عامة عندها حصانة بيسموها governmental immunity. الحصانة موجودة لرئيس الجمهورية، الحصانة موجودة لإلكتد officials، الحصانة موجودة للببليك سكولز. يعني ما بنقدر نقيم دعوة ضد الببليك سكولز لإهمال عادي، فينا نقيم دعوة ضد البرايفت سكول لذات الإهمال. يعني ذات الإهمال هو ordinary negligence. إذا كان برايفت سكول بنقدر نقيم دعوة ضدهم ونربح، إذا كانت بابليك سكول ما بنقدر. ليه؟ لأنه عندهم الحصانة. بس الحصانة ومثل كل قاعدة في إلها استثنائيات إلها. الحصانة هي مش 100%. الحصانة بتنرفع إذا كان الإهمال جروس، يعني كتير فوق الطبيعة، كتير بالغ،
ممكن يكون مقصود أحيانا يعني
صار intentional tort. an intentional tort it's different بنحكي عنه. negligence يعني مش مقصود. definition تبع negligence by definition it's not intentional. gross negligence يعني إهمال، بس شو هالإهمال الفظيع؟ يعني واضح انه اهمال، واهمال ما بينقبل، واهمال the conscience ما بتتقبل، والضمير ما بيتقبله، بس مش مقصود. بيقول هون انه اذا كان نوع الاهمال، يعني بدك تطلع هون على الفاكس، بدك تطلع على كيف صارت الإصابة. إذا كان الإهمال فظيع شنيع، ساعتها الحصانة بترفع ضد الببليك سكول، وساعتها بنقدر نقيم دعوة كمان مرة مش ضد المدرسة، بل ضد الموظفين تبع المدرسة. الموظفين تبع المدرسة بيكون عندهم عقد مع المدرسة بتقول انه المدرسة هي will indemnify them، يعني هي بتمثلهم، هي بتدفع عنهم، وهي بتحميهم. أما بالنسبة للبرايفت سكولز ما في حصانة، ما في governmental immunity. هون ساعتها the facts are هل صار في إهمال من قبل المدرسة، من قبل الكوتش، من قبل أي إنسان خصه باللي صار، أو حدا من اللي هن موجودين يعني عم بيبرنوا التلاميذ. هون صارت أهين بكتير إنه نقدر نفنجي إنه صار في إهمال. So the difference هلا بالنسبة للتشير ليدر كمان مرة it's always بقضايا النيجليجنس، بقضايا السليب اند فول، تريب اند فول، بقضايا النيجليجنس. it's always very 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 fact specific. يعني ما فينا نقول كقاعدة عامة this يعني this يعني that، لا. it all depends on the facts, it all depends on the circumstances. So in the case of this cheerleader maybe yes maybe no. أول مرة ما قالت لها وقع عليها شيء، ما قالت لها للكوتش تبعها. تاني مرة قالت لها الكوتش قعد 5 دقايق على جنب، من بعد 5 دقايق ما تزمرت. ثالث مرة يمكن في علامة استفهام على ثالث مرة صار عندها إصابة. بس كقاعدة عامة هيدا الارتيكل أو هيدا الكيس اللي هو من الكاليفورنيا كورت اوف ابيلز ما بيتطبق عنا بمشكل. بس بدك تنتبه لشغلة رامي، كقاعدة عامة صحيح انه كل ولاية، صحيح انه في قوانين فيدرالية هي بتطبق على كل انسان لو بأي ولاية عايش، يعني قانون الهجرة، قانون البانكربسي، قانون السوشيال سيكوريتي، هدول موجودين ذاتهم بكل الولايات. بس في قوانين تختلف من ولاية لأخرى. however وإنما أغلبية القوانين متطابقة، وأوقات بيصير في دايما ولايات تاخد الطليعة قبل غيرها، وبتكون بالطليعة قبل غيرها، وبهذا السبب أوقات في ولايات بتلحقها، مثل القانون اللي حكينا عنه من تقريبا شي أسبوعين اللي هو عن religious marriages، الكتوبة اللي هي the Jewish religion، والكتاب اللي هو in the Islamic religion. هلأ ميشيغان caught up to New York and New Jersey. So فيني أكد لك إنه كقاعدة عامة صحيح كل ولاية عندها قوانينها، عندها قضاتها، بس المنطق هو ذاته تقريبا بيلحقوا بعضهم and they catch up to each other. هلا إذا بتشوف legislation عم تكسح كل الولايات المتحدة عن الأبورشن and so forth. So صحيح هيدا هو كاليفورنيا، بس ما بنستغرب إذا بيكون كتير قريب للكيس بميشيغان. بعد عنا 2 articles وعنا ربع ساعة. رح ننتقل لهوتيل. في هوتيل كان في عرس، وضيف من العرس سلت اند فول. فهذا الضيف صار عنده إصابة سيئة يعني، أو ضيفة. قرروا يقدموا دعوة ببورتوريكو، قرروا يقدموا دعوة ضد الأوتيل. المحكمة بتقول، بفتكر كمان محكمة الاستئناف الكورت اوف ابيلز ماني غلطانة، يس كورت اوف ابيلز ببورتوريكو قالت very sorry الأوتيل ما عنده liability. هون كمان هيدا بيفتح the chance إنه نحكي عن hotel security cameras, duties of hotel attendants vis-a-vis their guests. Attorney Howard Radner in Puerto Rico yesterday, a court of appeals did hold. Well, let me tell you what the scenarios are. The scenarios are that there was a wedding and there was a pool party for the wedding guests. And there was dancing next to the pool party. And, some of our kids, they go to Miami, Rami, and they party and they are dancing by the pool and there is water by the pool and all of that. So this is not a far-fetched scenario. Yeah. So the dance floor became very slippery, and the bride got the bright idea to use it as a slide, as a slip and slide. And so when she did that, guests decided to do the same. This is when a hotel employee approached the groom, the husband, and said, "This is dangerous." So the groom laughed him off and added salt to the water and made it even more slippery. Somebody followed the lead and got very injured and decided to sue the hotel. And after 2 days of trial, the court said that the hotel was not negligent. What this person who got injured said is, "I didn't hear the memo. The hotel, through your employee, talked to the groom. You did not talk to each and every guest to alert us that this is a dangerous condition." And the court said, a reasonable person, they prevented by the way, the hotel presented the video evidence of what was going on. And the jury said, anybody can see. You don't need anybody to tell you this is dangerous. Anybody, any reasonable person can see that this is a dangerous situation. So the hotel attendant did not have a duty to inform each and every one of you that this is a dangerous condition. Your opinion on that?
Yeah, well, I'd have to agree with the court on that. You know, sometimes people...
Yeah, this one is an easy one.
People will call and they had an incident at a swimming pool, at a hotel or a health club where they fell on the surface and injured themselves. They want to sue the hotel or the health club or the gym. So obviously inherent in a swimming pool is there's going to be water nearby.
Correct.
Inherent in a obviously people can't be expected.
So you kind of assume the risk up to a certain degree.
Certainly
yes.
assume the risk, and so the proprietor of that business is not going to be responsible. And for a wedding,
what
also,
about injuries in a gym?
The same. I mean, again, it depends what the circumstances are.
Of course. So it's always fact specific.
And of course, most gyms that I'm familiar with here in Michigan, and I suppose this might be true in other states, have a release of liability
when you sign up
contract.
with them.
And then in Michigan, the only way you can hold a gym liable for an injury is if the gym was grossly negligent, similar to in the governmental immunity situation. So that's very difficult to prove, and very, very hard to prove gross negligence in a gym. So most cases where people are injured in a gym, they're not going to be successful.
There is no substitute
recovering.
for common sense. Now, when you are at a pool, maybe there is alcohol and you are not in full possession of your capabilities, but one should apply common sense.
And I do remember many years ago, somebody called me. He actually fell on a dance floor, dancing at a wedding, and he wanted to file a claim against the proprietor of the place.
Yeah.
There's no liability there because the hotel did nothing wrong.
Right.
Just because the man slipped on the dance floor and injured himself doesn't mean that anybody was negligent.
It's very interesting because I think the judge in the hotel says, and I'm going to quote, "When someone gets hurt, lawsuits frequently follow. This is what happened here." And yes, sometimes when something bad happens, somebody decides to sue somebody, but that's not always, what happened is not always the result of the negligence of someone.
Correct.
Yeah. رامي ببورتوريكو كان في عرس، وكمان it's another case طلع امبارح من المحكمة العليا ببورتوريكو. كان في عرس والعرس انتقل للهوتيل next to the pool وبلشوا يرقصوا وكان في مي. فقررت العروس انه شافت المي، قررت بدها she's going to slide on the floor. لحقها العريس بيقرب الموظف تبع الاوتيل يعني بينبهه انه هيدي شغله خطره، بيضحك عليه، بيزيد صابون العريس. بيجي شخص تاني بيرقص وبيزحت يعني does the sliding، يعني عم يستعملوها كأنه slide، عم يستعملوا الأرض كأنها slide، وبيتأذى كتير وبيقيم دعوة ضد الأوتيل والكليم تبعه هي إنه الإمبلويي تبع الأوتيل هو بس حذروا للعريس، كان لازم يحذروا كل شخص واحد واحد. فالمحكمة تبع ترايل كورت بالإضافة للمحكمة تبع الاستئناف بتقول سوري، بس الأوتيل ما عملت شي غلط، مش واجباتها إنه تبلغ كل إنسان. بالإضافة الفيديو ايفيدنس فرجت إنه أي إنسان بيطلع على الظروف منه لحاله بيعرف إنه الشغلة خطرة، يعني منن بحاجة لحتى يبلغوا الأوتيل، منه بحاجة ليبلغ كل شخص لحتى يقدر يثبت إنه الهوتيل ما ارتكب أي إهمال. المحامي هاورد رادنر استخدم هاي الفرصة لنحكي عن بولز، لنحكي عن هيلث كلوبز. من وقت لوقت بيجينا اتصالات من أشخاص متأذيين بقلب الجيم، هيلث كلوب. كمان مرة أول شيء وقت اللي بتروح على بول وفي مي، يعني المنطق بيقول you assume some of the risk. ذات الشيء وقت اللي بفوت على الجيم. بالإضافة إنه وقت اللي بتعمل عقد مع الجيم أنت ما بتقرأ the fine print، مثل وقت اللي بتعمل عقد مع عقار insurance company ما بتقرأ the fine print، وأصلا إذا قريته ما فيك تقول بدي I want to take out this clause and I want to add this. It's not a private contract in that sense. So كل الجيمز بتصور إنه وقت بيمضوك membership معهم you release them of liability، إلا إذا كمان مرة إلا إذا كان الإهمال من قبل الجيم شيء جروس، يعني شيء شنيع، يعني شيء shocks the conscience، يعني شيء عن جد غير مقبول. So هيدي بالنسبة للإصابات in الجيم إلى آخره. آخر أرتكل وعنا تقريبا 6-7 دقايق عليه، هو منه أرتكل من المحكمة، هو أرتكل من an expert opinion. ما بعرف إذا قريت الأخبار أو سمعت عن الأخبار من تقريبا جمعة بهيوستن تكساس، كان في بيسبول جيم، ميجر ليج بيسبول جيم، وكان الاوتفيلدر ألبرت أمورا عم بيزطها بوطها اتهت 4-year-old طفل صغيرة موجودة بأول الصف. صارت هي تبكي وصار هو يبكي. والهيدا الموضوع بنحكي هون فيه، بنستخدم الفرصة لنحكي عن شيء بيسموه stadium liability أو liability in sports arenas. كلنا بنروح بنحضر بيسبول وباسكتبول و whatever بول، يعني ممكن هيدي كتير تصير. نحكي بطريقة سريعة ومنلخص. Last year there was a major league baseball game in Texas, I believe, and the outfielder Albert Almora during the game at the Minute Maid Park in Houston, Texas, hit a 4-year-old young girl. The girl got injured and she started crying, and he, Almora, started crying. And we're using this very quickly to talk about stadium liability or liability in sports arenas. So apparently there is something called the baseball rule, which has been followed for years and years and years, that almost gives almost entire immunity to baseball leagues in the event that their fans got injured. And, there has been a lot of talk about changing that and about imposing some kind of, responsibility on the part of the Major League Baseballs to put nets to protect the fans from the players. And you have people, on both sides of the aisle who are pro and cons. Those who are pro, like Almora and others, say it will dramatically decrease liability because apparently, and I think that Bloomberg did a study, and they showed that actually the number of injuries every year is surprisingly very, very, very high. I'm going to get it in a minute. The study done by Bloomberg in 2014 said that every year 1,750 fans are injured by balls hit in the stands. So you have that on one hand, and then you have on the other hand people saying, but it decreases the quality of the experience. We love the closeness between the fans and the players and all of that. So apparently there is a rule called the baseball rule, protecting Major League Baseball from being required to even put fans, and they've gotten away with it. And there seems to be a public outcry saying, change this. So there is no law. This is not law I'm talking about. This is more like a question of public policy, public outcry because of what happened to that 4-year-old girl. And Yankee Stadium last year, another very little girl was also very, very hurt in the Yankee Stadium. So, this legal commentator is saying this is a decision for the Major League Baseball. It's not for the courts. Very quickly, and apparently it all depends on how the stadiums are done, because back in the 1920s, the stadiums where the people were more farther from, fans were farther from the players. And now they sit more than 20% closer to their players. So that increases the likelihood of an injury. And also think about it, a baseball bat, it's so much speed. So you're not going to see it coming. And if you're looking elsewhere, you're not going to see it coming anyhow. And even if you see it coming, I don't know if you have time to respond because of the speed. Comments on that? We go to basketball games. We take pride in sitting front row. Should we reconsider that?
Well, yeah. I mean, occasionally those players will fall on the fans in the first row.
Right, and also the ball.
No,
I've caught the ball at the basketball.
I remember there was a case brought against the Detroit Tigers many years ago.
Yes.
When John Fetzger owned the organization.
Yes.
And I don't know how that case turned out. I don't think it turned out in the plaintiff's favor, but I'm not sure.
So what can you tell us very quickly about stadium liability or liability in sports arena? Is it pro-fan or is it pro?
I think generally speaking, it's almost impossible to hold the team responsible because it's inevitable that there will be foul balls coming into the stands. Everybody knows that.
Okay.
Another thing about this case that just happened last week, you wonder why the parents would bring a 4-year-old to a baseball game and seat that child so close to the field. First of all, why is the child being brought to the game?
Because it's fun for them. It's fun for them. I don't think people are thinking the way...
I know about 4-year-olds, and a 4-year-old is not going to appreciate watching a game. And it's dangerous. It's dangerous to sit close to the field with those foul balls flying all over the place.
Okay. So
the parents there should really not have brought that child to the game. So this is a caution
to the parents.
And if the parents are going to bring a little 4-year-old to the game, they should sit in the bleachers.
Now, are adults any less vulnerable to being hit?
Well, at least the adults know that they have to be watching every ball so that if it's coming their way, they're going to duck. A 4-year-old child
what happens to the selfies and the pictures and Thank you very much, Attorney Howard Radner. Rami,
so I would be on the side of the sports team, not the injured person.
Yeah. رامي الوقت ما بقى يسمح لنا بس بكره الله راد بنلخص شوي الاسبوع بنحكي عن هذا الموضوع.
شكرا
وشكرا للمحامي هاورد رادنر